My name is Kate Fitzpatrick. I'm the Executive Director of the Deschutes River Conservancy. Our mission is to restore stream flow and water quality in the Deschutes Basin. We were actually founded by the Confederated Tribes of Warm Springs in 1996. So I'm thrilled to have Bobby and Josh here to talk about the tribal connection to water and Indigenous water rights. The tribes are at the center of our work and are the driving force behind our collaborative approach. Thank you to our sponsors who allow us to offer this seminar series for free. City of Bend, Mount Bachelor, and Sun Country Tours, Hand in Hand Productions, Open Space Event Studio, Patagonia, Central Oregon Intergovernmental Council, Mount Bachelor Rotary Club of Bend, and Wanderlust Tours. We're always looking for more sponsors to keep this rolling, so let me know if you're interested. We honor the Native people who have called this region home for thousands of years. We join them in stewardship of our rivers for the next 7 generations and beyond. Now I will introduce the panel. Robert Bobby Bruno in the middle. Bobby is an enrolled member of the Confederated Tribes of Warm Springs. He is currently the Secretary, Treasurer, CEO for the Confederated Tribes of Warm Springs. He's also the Tribal Historic Preservation Officer for the National Historic Preservation Act. Previously, Bobby served as the General Manager of the Branch of Natural Resources for the tribe, where he oversaw the protection and enhancement of the Confederated Tribes of Warm Springs' natural and cultural resources, including the protection of the tribe's treaty-reserved rights both on and off the Warm Springs Reservation. One of the best parts of my job is getting to work with Bobby on a close basis. If Bobby were a water body, he would be a deep mountain lake because he is almost always calm, but belies great depths. I've learned so much from his thoughtful approach to complex water management issues and partnerships. For being one of the busiest people that I know, Bobby always takes the time to slow down, build relationships, have conversations, and if you take the time in return, you will be regaled with many stories. And when Bobby's not devoting all of his time to natural resource stewardship and now leading the tribes, Bobby likes to golf, watch car racing, and eat Mexican food on Fridays. Josh Newton is a private practice attorney and a partner with Best & Krieger. Josh advises clients on environmental and natural resource issues. His practice includes complex litigation in state and federal courts. Josh has represented the Confederated Tribes of the Warm Springs Reservation of Oregon for more than 20 years. In getting to know Josh more closely over this past year, I've come to love watching him speak as he is a fount of just total smartness. So I'm not yet sure what body of water Josh would be, but maybe he can speak to that himself. Last but not least, the amazing Lisa Seals, Program Manager at the Deschutes River Conservancy, will be your facilitator tonight. So I'm going to hand it over now to Lisa.
I have my own mic, so you get to keep
you.
that. All right, thank you so much, Kate, and thank you everybody for being here. Just curious, how many folks in the audience have attended a Raise the Deschutes seminar prior to this one? Okay, I like it. I like to call you all repeat offenders, but no, I really appreciate you all for continuing to come out and be interested in learning more about water. We have a really special presentation tonight, and I feel like I'm going to play a little bit of a different role than I have in the past because this is not a topic of conversation that I feel very well versed in, so I'm learning right along with everybody in the audience, so I'm going to do my absolute best to try to make it as understandable and accessible as possible. And so to that end, we're gonna try to have everybody hold their questions until the end. We're really gonna leave time for questions and answers at the end of the presentation. But if you do have a clarifying question, something that you just is really hampering your ability to understand what's being talked about, those are the kinds of things that we'd love to see your hand and just shout.
So that scaffold there is what they call a set net scaffold. So that's a scaffold where they put the net down in the water and they hold it and they wait for the fish. There's also other scaffolds there that are dip net scaffolds, and that's where you see them moving their net all the time like this. So there's 2 kinds of traditional fishing happening there on those scaffolds. A lot of folks always assume that all these scaffolds are dip net scaffolds. They're not. There's set net scaffolds. But that's a very important place to the tribes. And it's one of our places where we do subsistence fishing. And so we have a lot of tribal members that go down there every year, and I'm one of those people that's down there every year. The tribes, who we are, where we come from. So there's the Confederated Tribes of Warm Springs is made up of 3 tribes. You have the Warm Springs tribe, the Wasco tribe, and the Paiute tribe. And so that makes the Confederacy there in Warm Springs. And then where we come from, you have the Wasco people come from the Columbia River, Warm Springs people come from the Columbia River, and then the Paiute people come from southeast Oregon in the high plateaus is where they're from.
Let's try this again.
And
Southeast Oregon?
yeah, there you go.
Yeah.
And then the in that photo there that you saw with the fishermen on the scaffold, that was at Celilo Falls on the Columbia. And that was the main fishery. That was the place where we all went to fish. Unfortunately, that was inundated by the Dalles Dam, and so the falls are gone now. Unfortunately for me and some of my family members and others and tribal members my age, never got to see those. So those were inundated. But my grandmother and my father, they used to live down there and fish down there, and so I got to hear the stories as I was growing up. So I really like this photo of the 2 young people there on the scaffold sitting there with a set net waiting to catch fish. So, all right.
I learned today too that they are tied in, which sense of comfort there, or not if you fall off and you're dangling from your tied rope.
They're usually long enough to go into the water, so hopefully your friend's there to help pull you out.
All right, so we can, I guess we can just
Yep.
quickly, oh my gosh, sorry. I got a new clicker tonight in case you hadn't noticed. So I'm learning the ropes right now. So the area here is the Deschutes Basin. So just as another orienting everyone to where we're talking about.
And a little bit about our culture. This slide's a special slide to me because this is a slide that I went and had these ladies that were in their 80s, in their 90s, and they were part of our culture committee. We have different committees for the tribes, and they were their culture committee. And one of them was my grandma. She was like 92 at the time. And so I told them I do a lot of presentations and go and talk and give these to groups like you. And I said I wanted to talk about the Creator and a little bit about our culture, and I wanted to see if it was okay to do that. And so I presented this slide to them, and they said yes. They were glad that I was doing that because they wanted other people to learn about us and understand us a little bit better. So with that, this is things that are important to the tribes, and these are gifts from the Creator. And the Creator gave us gifts in order. First thing He gave us, or she gave us water. And we're supposed to take care of that water, protect that water, and make sure it's there for future generations. And we should always take care of that. It's very important to us. Then the fish, the salmon, all the fish in the river. And we're fish people. We're from the Columbia, and salmon is very important to us. It's part of who we are in our culture and spirituality. Then it's the wildlife. You know, the deer, the elk are very important to us and sustain us, and we should not take any more than we should be and looking out for them. And then our roots and berries. So the huckleberries, the chokecherries, the roots. I always have to think about this because I know I'm an Indian and I always have to think about English. Pyaki, which is bitter root. So it's kind of a long, stringy root, which is actually my favorite, which is why I talk about it. And so the roots and berries. And so these are things that the Creator said take care of for future generations. As you heard Kate earlier talk about 7 generations, and we've got to look out for these. And so this is part of who we are. It's part of our spirituality, and so very, very important to us in our land. So So that's a special slide. And I like that photo, and I've times I thought, well, maybe I'll change out the photo and put a different one, but I sense these ladies that are all gone now. They have all gone. And I thought, no, I'll just leave it. It's a great photo anyway. So our treaty. This is a photo of our treaty of 1855 that we did with the U.S. government. And it's got several documents, and if you ever see the very end of the treaty, you'll see all the signatures, and actually they weren't signatures, they said marks. And so one example on there is Dog River people, which are Wasco speaking people. There's 143 marks of people that signed that, and then there's others in different bands, and we were different bands that come all together. The important thing about our treaty is we reserved rights. So you see the word highlighted there in bold and underlined, reserved. And we reserve rights to fish, hunt, gather our cultural foods, and to pasture livestock on unclaimed lands. And unclaimed lands, what are those? Those are federal lands. Those are Forest Service lands. Those are the BLM lands. So those are the unclaimed lands. And in our ceded lands and in our usual and custom sites. And I'll talk about the ceded lands here a little bit, and also the usual and custom sites. I always put this on the bottom here, this last bullet. The U.S. government has a responsibility to protect and enhance these resources that are important to the tribes that are identified in the treaty. And again, back to the word reserved, the tribes, we never gave up anything. We never gave up our rights. We reserved these rights. And so that's a very important thing. That's something we always stress. It's something the tribal elders and the tribal councils that I've worked with over the years, and the current one, we always remind folks that we didn't give things up, we reserved them. So that's a little bit quick on the treaty, and that was signed on June 25th, 1855, in a little place called Owasco, under a great big oak tree.
It's like a beautiful place to sign a document.
Yeah. So here's a map of our ceded lands. So we ceded lands to the U.S. government, and it's 10 million acres, and that takes in most of the Deschutes Basin, all of the John Day Basin, and all of the Hood River Basin, where we reserve these rights. And then in the purple there, it says Warm Springs Reservation. That's the reservation itself. And then all those purple spots like that one, and over on towards Columbia and the John Day, up by John Day and Prairie City, which is over to the east there. Yeah. And yeah, over there. And then you come all the way back over the crest of the Cascades, and there's that Austin Hot Springs on the Clackamas River, over in Yamhill County, Red Hills, and over on the Sania Pass, Little Sweden. And these are all lands the tribes own. We own all these purple spots here you see. They're owned by the Confederated Tribes of Warm Springs. And there's approximately another 57,000 acres that we own away from the reservation. So and why are we have lands over in the Willamette Valley? Back to the usual and custom sites. So we reserve rights for exclusive use on the reservation. We reserved rights in the ceded lands, but we also reserved rights in these usual and custom places that are not defined by a boundary. The reservation and the ceded lands are defined in the treaty, the boundaries. Usual and custom sites are places that we've gone to fish, like Willamette Falls, where we have a fishery every year where we gather lamprey, or eels, we call them. We have usual and custom fishing that we do in the Cowlitz River. We set a season every year down in the Cowlitz River for smelt, and we go get smelt in the Cowlitz River every year. We have huckleberries that are gathered by our tribal members up in the state of Washington in the Gifford-Pinchot National Forest. They go a lot of times they go up to a place called Trout Lake and go gather berries. So those are places are usually custom sites. So it's a pretty broad, and it's where family units and bands used to go to gather. Now, why do we have those? Well, when the treaty was being negotiated, not everyone was there for the negotiations, so they knew there were some others, tribal members, that were gone on other places, like over in the valley, in gathering and hunting and fishing. And so they also wanted to reserve rights for them to where they go, and they didn't know exactly where everybody went, but they wanted to make sure that was taken care of too. So that's why we have usually custom sites, and some that I've, as an example of some that I've just described.
So I think our next slide shows the ceded lands in blue and the reservation and how that relates to the basin. Oh, excuse me, the ceded lands are in white and the Deschutes Basin is in blue there. So basically pretty much the whole Deschutes Basin.
Yeah, and just to describe a little bit the ceded lands, most of you know where Cascade Locks is. And so just downstream of Cascade Locks, center of the Columbia River, head south, crest of the Cascades, and you go crest of the Cascades south, down just past Bend, there's the 44th parallel. And then from the 44th parallel, from the crest of the Cascades, head back east. And then kind of out in the middle of nowhere, out in the desert, it turns and goes back north into the Blue Mountains, goes the crest of the Blue Mountains over to a creek called Willow Creek, and then it heads down Willow Creek back to the Columbia River, then mid-channel of the Columbia back to the original point just past Cascade Locks. So that's described in the treaty, and that's the boundary of the ceded lands.
All right, the reservation.
The reservation. So the reservation is for the tribal members, and it's exclusive use of all those resources there, and it's talked about in the treaty. And the reservation is 640,000 acres or 1,000 square miles. The forest you see there in green is actually the larger amount of the reservation. A lot of folks don't know that because when they come through Warm Springs, they come through the desert part. But there's 444,000 acres of forest lands on the reservation, and the remainder's in rangelands. The reservation goes to the top of Mount Jefferson. I don't think a lot of folks know that, but it goes clear to the top of Mount Jefferson, down from Jefferson south over to Jefferson Creek on the south boundary, down Jefferson Creek, over to the Metolius River, down the Metolius River, over to the Deschutes River, and then about 32 miles of Deschutes River on the eastern boundary, back over to what we call the McQuinn Strip. That line on the north side there goes up and makes that little point and comes back down again. So that is the reservation. There are several communities there. You have Warm Springs, you have Simnasho, you have Sidwalter, you have Siksika, and so those are the communities in Warm Springs. A little over 5,300 tribal members. This is taken from the last census. And then I always get the question, how many tribal members live on reservation or off reservation? Well, that's why I put that number in there. So there's about 1,400 tribal members that live off reservation. So that's the reservation and some of the tribal members. How many we got?
All right. So just out of curiosity, before we start into this, I'm curious how many people came to the seminar where we talked about water rights. We have a handful of you. Okay. Does anybody remember when prior appropriation and became law, Oregon water rights? Anybody? All right, 1909. So, and about that same time, this is this is what was going on as well. So settling of water rights, and I think Josh is going to talk about this.
Yeah, I guess I'm up, but before doing so, I politely declined Kate's invitation to, I guess, self-assign to a water body. I've been sitting here racking my brain and I'm not sure, so maybe I'll come up with something. And
A babbling brook.
yeah, I was trying to think it was like saying like a ferocious ocean surf, or I don't know. And also, Bobby and I have worked together a long time. We presented a lot together. He's my favorite person to present with because I almost have to do nothing through these presentations. And just let him present because that's who everybody wants to hear. But I'm going to provide some overview of a legal framework as it relates to water rights, tribal sovereignty. And we'll see how we do. Lisa's going to try to keep me
I'm going to try.
Yeah. But maybe, we did prep a little bit earlier today, but for those of you that weren't here in the past and sort of water rights and water law, generally speaking, and we'll talk about Oregon, but this is broadly applicable in other Western states, water rights are managed at the state level. They're not managed by the federal government. So the states, and what are water rights? They're the right to use water for beneficial purposes, generally speaking. And that includes both surface and groundwater. And tribal water rights are a notable exception to that framework. And that, I think, is important to know because it creates has created a lot of uncertainty over the years.
Yeah, and I might add that beneficial uses were pretty much out of stream uses. That's how it was defined, right? So industrial uses, agricultural uses, cities and communities, stock watering, things like that. So when water law became in 1909, that was how it was defined. So obviously the idea of keeping water in stream to protect resources was not included as beneficial. So that's why this is important.
That's correct. And generally speaking, the water is owned by the state in trust for the public, and the water right is merely a right to use water that can be lost through non-use. So sort of with that framework, and then the other piece that we talked about that I'm going to cover very briefly, but is important, is the notion of tribal sovereignty. So as Bobby's going through the treaty, what entities can enter into treaties? But there's only sovereign entities. And what does it mean to be sovereign? And it really boiled down means the right to self-govern. And so in the United States, federally recognized tribes for sure, and in Oregon there are 9 federally recognized tribes, possess ancient sovereignty. And what I mean by ancient sovereignty is sovereignty that predates the founding of our country. And how do we know that? We know that when the European powers were entering the colonial period, and so for us, England comes and colonizes the eastern part of the United States, international law at that time recognized that indigenous people of the places that were being colonized had certain sovereign rights. And those sovereign rights were not extinguished by the colonial power. And in fact, the law of nations at that time imposed on the colonizing power, who they identified as the more powerful sovereign, certain fiduciary responsibilities to protect what they call the weaker sovereign. And I'm not meaning to be politically incorrect or anything like that, but if you sort of look at the way the law and some of the ancient texts, that's the way it was described. So you had the tribes in the eastern part of the United States, and one of the other issues that they faced was, well, what do we do with the territory? And the European powers conveniently sort of invented a doctrine called the doctrine of discovery that essentially said the European power that is recognized as the colonial power actually has the legal right to occupy the territory of the area that they've colonized. And the indigenous people do not have property ownership. They merely possess a right of occupancy at the sufferance of the colonial power. So that was really the legal framework that existed pre-revolution, and that ultimately got wrapped into our Constitution through the revolutionary period. And I'm not going to go into that detail, except to say the notion of tribal sovereignty is constitutionally recognized. There are 4 sovereigns identified in our Constitution: the United States itself, the individual states, foreign nations, and, quote, Indian tribes. Colonial period in the United States, the authority to regulate affairs with the indigenous people resided with the Crown and not the colonial governments. That concept got carried over into our Constitution, what they call the Indian Commerce Clause. And it vests with the Congress of the United States, and specifically Congress, not the president, not the executive branch, not the judiciary, what they call the plenary authority or total authority to regulate the affairs, tribal affairs within the United States. And that exists to this day. So we go through, we recognize sovereignty, we recognize this fiduciary relationship that gets enshrined into our national law through a series of US Supreme Court decisions that says tribes are sovereign. The United States owes a fiduciary obligation to tribes, which is called the tribal trust obligation. And state law generally does not apply in what is in federal statute called Indian country. Now, some people may, again, think a lot of these phrases are anachronistic, and perhaps they are, but they really are sort of the key legal doctrine. So we sort of fast forward, and I'm going to really go fast forward through the 19th century, and we're right, manifest destiny. You're having people move across the United States. There's different epochs and periods historically where there's a removal period, and the indigenous people of the southeast part of the United States get removed to Oklahoma, and then they get moved again. And so you move along, and by June 25th, 1855, and you're in the Pacific Northwest, the Washington Territory, the Oregon Territory, you're past the era of armed conflict largely between the United States and tribes, and you're nearing the end of the time where the official policy of the United States was enter into treaties with tribes. And there are 4 Columbia River Treaty tribes. There's Confederated tribes of Warm Springs. There's a Confederated tribes and bands, the Yakima Nation in central Washington. There's the Confederated tribes, the Umatilla Indian Reservation in Pendleton. There's the Nez Perce tribe. All 4 treaties were negotiated in June of 1855. And all 4 treaties were negotiated because Congress had passed the act opening up these territories to settlement, and they had to deal with Aboriginal title. So these 4 tribes have these treaties. Now, not all tribes have treaties, but lots of tribes have reservations. If you go through the Warm Springs Treaty and other documents establishing or recognizing reservations, virtually none of them are going to mention water or the right to use water. They're silent. The U.S. Supreme Court decision in Winters versus the United States arises out of a reservation in Montana, and it dealt with the right to use the surface water of the Milk River. And the non-tribal water right users, really ag interests, were challenging the right to the tribe to use the waters of the Milk River. And the issue made its way clear to the Supreme Court, and the principal argument was there's nothing in this reservation, the reservation language, that reserves the right to use the waters of the Milk River. And the Supreme Court applied what we call canons of construction, but basically ways to interpret the text that are favorable to tribes because of the language barriers and different things, and said, look, it really defies common sense that you would reserve an area to be for the exclusive use and occupation and become a permanent homeland for these people if you didn't reserve water to sustain themselves. And many of the reservations in the Midwest, the Southwest, also had a really big assimilative component to take the Aboriginal people and indigenous people and turn them into farmers. And so the argument was, look, there has to be sufficient water to actually sustain an agricultural economy. So that was the winner's decision. The winner's decision is it's federal law, not state law, that determines the federally reserved water right. This is very broad, and there's lots of exceptions, but the water subject to the right is generally the waters that arise on, border, or adjacent to the reservation itself. That's important when we talk about the Warm Springs Water Rights Settlement Agreement in a minute. And because we're in the western United States and we have the doctrine of prior appropriation, which is first in time, first in right, it was necessary to identify a priority date for tribal reserve water rights. Often it's the date of the reservation itself, but actually Oregon in the Klamath tribe, there was Ninth Circuit case that identified that if tribes were relying on water for sovereign purposes before the date of the reservation, that priority date could actually be what they call from time immemorial, but the earliest possible date. And we'll talk about that a little bit more. We can move along. So the water rights are reserved to carry out the purposes of the reservation, so that requires some sort of judicial inquiry as to what is the purposes. As I mentioned, because you were really looking at forced assimilation and the notion of having our indigenous people become farmers or ranchers, that they were really looking at the quantity of water needed to irrigate these reservations. And they developed what's called the practically irrigable acreage standard. And it's a pretty simple standard in some ways, but it's really looking at the soil. Is it arable? Can you actually farm it if you put water on it? And then the next question is, can you actually deliver water to that acre in an economic fashion? So if we were talking about this today, if it costs you $200 to deliver water to that acre, but you can only grow $100 worth of crops, it would be determined to be not a PIA acre. So there's an economic component, an engineering component, and so as you might imagine, that is really arbitrary and ignores tribal sovereign interests and cultural resources. And so tribes have been looking for ways to reach settlements or adjudications that actually account for their sovereign needs for water. And we'll talk about how Warm Springs accomplished that. What these tribes can enter into leases of water. The water rights themselves are trust assets. We talked about the trust relationship, and what that means is the United States actually owns them. The tribes have a beneficial interest in them, and so they can't convey the right without the United States consent. And water quality is another important component. I feel like Lisa's going to have a hook at some point. But so and Bobby will go through the timing a little bit more, but really by the 1970s, the United States had come to the determination that the adjudicating tribal water rights was very expensive, time-consuming, outcomes uncertain. And they began to think about, could we facilitate a settlement process for some rights? And Warm Springs is actually selected as a tribe that had promise for that. So I've sort of covered that other bullet point. So now we're back to Bobby.
Okay, thanks, Josh.
So here's some timelines on water for the tribes. The tribes have always, as you heard me talk earlier about cultural significance and water being very important, they've always talked about water. So in the 60s and actually in the late mid-50s, the tribes got their first attorney working for them and looking at these things, and that person happened to be a federal judge also later on, was Owen Panner, and Dennis Carnop came to work for him. And so they've been in that firm, had been working with the tribes since 1955 to date. And so they've been with the tribes for a long time. And so they've helped us on the legal side in helping us protect our reserved rights, our sovereignty, and talking about our water. In 1967, we had the first water code of any tribe at the time had been done. I don't know if any other tribes have done one yet. I'd have to look, but in 1967, we were the first tribe to do a water code. In the 1960s, there's quantification of our water and discussions of that, and so that was important to the tribes. And and they were already thinking about what are we going to do for our water rights? What are we going to do? How are we going to secure our water? So these were all steps leading to that. In 1981, the tribes, I'm looking at the screen down here, and U.S. initiated efforts for tribal reserved rights. In 1985, they start forming their negotiating teams there, so the tribes, the U.S. government, and the state. And there was a piece with the state that they had to go to the legislature to figure out their negotiating team with the tribes at the time and put them together to be able to have the discussion with us in 1985. The other is 1997 was the negotiations were wrapped up and had our final decision on that. That was I remember that day because we had Kanita, we had the governor there at the time was Governor Kitzhopper, who signed the agreement. We had the Secretary of the Interior there, who was Bruce Babbitt at the time, come in and sign the agreement. So it was a big deal. Of course, all the tribal council and our chiefs were there. So it was quite a day to witness and be a part of in 1997. And then in 2003, we went to the courts and happened here in the Deschutes County Court and to finalize everything and enter the settlement agreement decree. And Judge Tickton was the judge at the time when we were there. It was an interesting day. Josh and I we were both there, and one of the things that stands out for me that day was so we had our tribal leadership there. It was a big important day, so we brought our drummers to be able to sing a song and prayer. And so they asked the judge if that would be okay to do in the courtroom. And he said, yes, that's fine. And so the drummers started drumming and started singing a song. But the police officers out in the hallway didn't know that. And they all come busting in the doors. And the judge is like, no, it's all right, it's all right. So that was a memorable moment for definitely Josh and I on that. So some important dates there, and we have some other dates in between there. In the 70s, USGS putting in gauging stations and different things to see what our flows were. That so there's some other timelines in between these major ones here. And what's important to the tribes. You heard me talk again, the water and the current and for future generations, 7 generations out. This is important to these negotiations that we're looking out for these future generations as this one elder that I work with and, looking out for the unborn and making sure they have something later on into the future. One of the main drivers in our talking about our water rights was fish. Again, back to we come from the Columbia River, we're fish people, we're salmon people. And so looking out for that resource was a high priority in these negotiations that we had enough water for those fish. And you heard me talk about usual and custom and ceded lands. So with that, when they were deciding how are we going to negotiate these and what the tribes did is negotiated all the waters on the reservation and bordering the reservation. But it goes bigger than that. So the tribes also have talked about how do we reserve our water rights off the reservation in our ceded lands and in our usual and custom sites. So that's a big discussion, and that's something I know the past tribal council that I talked about is how do we secure all our water, not just on the reservation, but everywhere where we have rights. And that's a large discussion. So let's start where we know we can get something done, and that's with the waters on the reservation and on the borders. That'll be a long-term thing, and whoever ends up working on it, I probably won't be one of those people, but it's big. And I thought it'd be important for this group to know, and others, that our water rights are not just the reservation. We have other places that we're looking at. And as I said earlier, usual and custom sites and our ceded lands.
That wasn't me.
And again, it's between the Confederated Tribes of Warm Springs, State of Oregon, and the U.S. government. Purpose: determine fully and forever the tribal reserved water rights for lands within the Warm Springs Indian Reservation. Again, within the boundaries and on the reservation, and to protect our fish, and also being a co-manager on these resources that we co-manage with the State of Oregon and with the federal agencies to look out for these treaty resources.
So my clarifying question is, this is in lieu of doing a full adjudication? Like you did the settlement instead of adjudicating the water rights?
Instead of
instead of-
fighting in court,
Yeah.
yes.
Okay, so got it. Just wanted to make sure that, yeah,
And it still took 20 years.
20 years, yeah. How long does an adjudication take? Could take a whole lot longer than that.
Yeah, the Klamath adjudication, which includes an effort to adjudicate the reserve water rights of the Klamath tribe, I think was initiated in 1976 and is still going on.
Wow.
So,
Yeah, in our negotiations too, you saw those timelines, but when they formally started the talks, it was like 14 years. And there was a point, at one point, the tribes walked away from the table for a year, and until they come back with the state. So. Well, basis of the tribal reserved water right is the treaty that we talked about earlier. Reserved rights are held in trust by the U.S. government to benefit the tribes and allottees. What are allottees? Allottees are tribal members that have land on the reservation that are held in trust by the U.S. government. So they own a piece of property on the reservation, but it's not like fee land where it's taxed, and so it's held in trust by the U.S. government. We have a consumptive right and an in-stream right, and we'll talk about that a little bit more on some other slides that are coming up that'll give you some good visuals. And priority dates are earlier than other water rights and Deschutes. The basin state water rights with priority date of January 15th, 1991, and earlier may be curtailed in favor of the tribal reserved water rights. So those are our water rights, and go to the next slide. So this is a visual of our consumptive right and our minimum flow. So the minimum flow is the right that's in-stream. That's the in-stream water, the minimum flow. So that's when talking about the Deschutes River and keeping that water in there for fish and ecological needs for the river that are important for all of us. And then you have the tribe's consumptive right, which is water for our community. And so there we have 250 CFS of water for our communities, which is a 100% consumptive right. This is, use it all the way up. It's different than what you guys are used to for consumptive right. And also, we also have a 200 CFS consumptive right that we can market. And right now we haven't leased any water at this time, but we have another 200 CFS of water that we can market. And when we talk about CFS, and Josh had talked about practical irrigable acres earlier, and our water right is done when we negotiated in CFS, cubic feet per second. And practical irrigable acres and acre feet have time frames. There's rules to it. There's a time frame of how long you have to use it. It's usually during the season, growing season, and that. The tribe's right are in CFS, which is 365 days a year, 24/7, and so it's a lot of water. And we'll have some visuals to show what that looks like here.
Yeah, and that's in comparison to the water rights that we've talked about before that have a rate and a duty and a season. So a certain amount of water for a certain amount of time.
And I would also add that the tribe's water right cannot be lost to non-use. And we'll talk about that with some of the important takeaways at the end. So.
Okay.
I'll let you talk on this one. I'll let you do a slide here.
Thank you, I think.
Josh likes this slide, and it's a good slide. So.
It is a good slide, and these images actually were originally done as part of the settlement negotiations, and so we were able to take photos of them and add them to slides because we think they work well. But the water column on the left is, so as part of the negotiations, the parties, the tribe, the state, and the United States, with their experts, calculated what they thought the practically irrigable acreage of the reservation would be. And they determined that annual quantity would be about 116,000 acre feet per year. And then they said, well, wait a minute, and this was innovative. The tribe and its leadership said, we weren't farmers and we're not farmers, and our reservation that was reserved to us was not reserved to us because it was particularly valuable farming land. In fact, it's the opposite. They have very little arable land on the reservation, and everybody who's driven through the reservation to pump water, at least from the surface water sources, out of the Deschutes and up onto the mesas is expensive, and that by the cost to deliver water would really mean the tribe wouldn't end up with much. And the tribe said also, look, what we care about is in stream, keeping water in stream for our fish, right? And the ecological function of the rivers. In the scope of the settlement agreement geographically, and this is important, this is a takeaway, is if you live in the Deschutes Basin, you say, oh, Warm Springs has a water rights settlement agreement. That's true, but the scope of it includes only the waters that arise on the reservation or under the reservation or adjacent to, meaning that part of the Deschutes River that borders the reservation, the Pelton Lakes or Lake Billy Chinook, and the Metolius River. It does not include the middle Deschutes, the upper Deschutes, that portion of the Deschutes that exists below the reservation or the Crooked River. The tribe retains reserved water rights in those areas that have not been settled or adjudicated. You might ask, well, what are those water rights? Part of what it is the reserve right to take fish. The Ninth Circuit Court of Appeals has said, what good is a reserve right to take fish if you don't have fish to take? And so what do you need to have fish to take? Can I ask the audience a question?
Yeah, do it.
Okay, what's the one thing you need for fish? Well, you need other things, but essential thing. Water, right? And so, and then you need habitat and things like that. And so what the Ninth Circuit had said, and what's called a famous case called the Culver's case, and then it dealt with fish passage barriers, but essentially there's an environmental servitude created by these treaty reserve rights to maintain sufficient habitat for a harvestable population of fish to meet the treaty obligation. And that is a legally enforceable right, and the Columbia River Treaty tribes are the only tribes that I know of that have that right. Warm Springs, Yakima, Umatilla, and Nez Perce. So, Warm Springs was arguing in the 1980s and 1990s, we need water to support the anadromous fishery in the Deschutes. So they calculated what that would be, and the water column on the right is a representation of the amount of water secured to Warm Springs as compared to what it would have achieved under the PIA standard. Now, one last piece that we talk about today, but it's kind of an interesting piece of history. tribal water rights usually come in two forms. Water rights that are ultimately approved by Congress, usually comes with substantial funding to help implement the water settlement agreement, perhaps authorizes the marketing of the water right, or they're not approved by Congress. And if they're not approved by Congress, there's limitations and whatnot. The Warm Springs Water Rights Settlement Agreement, as it stands today, has not been approved by Congress because there were 2 members of Congress, 1 senator and 1 member of the House from the state of Washington, that were never going to allow Congress to approve this settlement agreement because of the innovative methodology that the parties used to quantify the water right. And they did not want it to stand as precedent for tribes in the state of Washington. So that's at least part, and so as a result, there's never been any money appropriated either to help the tribe implement the settlement agreement.
And they're both gone now.
And they are both gone, that's right.
The Congress members?
Yeah. So anyway.
All right, I think that brings us to our key takeaways for the evening. So yeah, I asked Bobby what we wanted you all to come away understanding and knowing after this evening, and this is the list of things we came up with. You want to go through it, or you want me to go through it?
You can go
All right.
through it. Yeah, that's fine.
So basically, who the Confederated Tribes of Warm Springs are. So this is the pop quiz. What are the 3 tribes? Yeah, all right. I feel like we got 100% on that one. Okay, so, and the Treaty of 1855 and where it is exercised. So everyone understands the ceded lands and the usual and accustomed lands. Get that right? And an understanding of the tribe's water rights that come from the settlement agreement that we just got done talking about, and how that was the quick way to do it as opposed to adjudicating those water rights. Obviously, the importance of water to the tribes and fish and all of the resources that are important to the tribes, and the legally enforceable rights in the Deschutes Basin. Do you want to follow up on that one at all?
Yeah. I think, recalling the lunch I had with Kate a few months ago, one of the important things, I've mentioned this twice, I think, tonight, is the tribe's rights cannot be lost to non-use, which is good on the one hand. On the other hand, and specifically, if the tribe has 200 CFS that could be used out of stream, but it's not currently using it, and people aren't aware of it, then people make decisions about allocating water in the basin, assuming that that water that is in the river will always remain in the river. And this is me representing the tribe. My worry is, and my opportunity is to say, people need to be aware that that water, sure, is currently in the river, but they ought to act like it's not. Otherwise, what you do is you create a situation where the community in the basin that is sort of least able to sort of support things is leaving 200 CFS of water in the river for the benefit of everybody with no remuneration, no benefit flowing back to them. And, you know, my view is sometimes we're all shy about thinking about what the moral proposition is around that, but my view is that's an important moral question to ask ourselves. We can talk about a whole variety of things with a habitat conservation plan and in-stream flows, the middle Deschutes, water quality issues, but fundamentally, if we're making these decisions because we're ignorant of the fact that there's 200 CFS that's currently residing in the Deschutes as it's bordering the reservation, because the tribe culturally, you know, that's a very serious conversation as to whether they should ever use it out of stream. But that's their choice. We ought not free ride on it from an economic perspective, perhaps. I would offer that to the group. I'm not, maybe that's soapboxy a little bit, but people can disagree.
You are on the stage.
I am on the stage. I know, and I was a little worried. I looked at that and I thought, I didn't want to fall off.
Bobby, do you, oh, sorry, go ahead.
No, I was looking at Ned, and I guess the one thing is, I'm glad nobody has suggested that the type of water that I am is treated effluent, so.
So before we move into questions, do you have any last thoughts or words or takeaways that you'd like to share?
Yeah, I just hope that we were able to give you some good information, that you learned something about the tribes and what's important to us, what our water rights are. They're very complicated. We've boiled this down quite a bit. Our presentation that we've done before, Josh and I, we have a PowerPoint that's like 39 slides long. That really gets into the details of things. We didn't want to do that to you guys tonight, but we just really want to make people aware that this is important to us. We follow it very closely. We watch it, and we report to our tribal council. Josh and I were just with tribal council here recently, talking about the water rights, because we have a new tribal council, so we were getting them up to speed to understand the water rights that the tribes have. So, but it's very, very, very important to the tribes.
All right, and with that, I think we will take questions from the audience. Looks like,
Steve.
wait, hold on. Wait for the mic
Steve,
if you don't
I'll
mind.
hand you
Got
this
a,
microphone first.
yeah, got a microphone circling the room.
Yeah, so towards the tail end, Josh, when you were talking, beside the immediate rights that are on the reservation lands and are going by or are custom, like with the Crooked and the tributaries, can you explain the treaty rights in association with, once you start going up the Crooked? I heard co-management of the resource, but help
Yeah.
me a little bit more, on clarity of the role the tribes have under authority, and then also under the vein of the expansive side of ceded lands, et cetera.
Yeah, happy to, Steve, on one condition, that you introduce yourself.
Steve Johnson
And
with Arnold Irrigation District.
that's good. It's good to see you, Steve. Yeah, Bobby, is it all right if I expand a little bit more?
Yeah, and I'll tag on.
Yeah, so you asked kind of a two-part question, a little bit about the source of authority for tribes to co-manage the natural resources. And maybe in two different ways, there's a variety of sources of authority, but for the tribe, it would always start with the treaty, the recognition of its sovereignty. It was managing these resources pre-Revolutionary War, and there's always been a recognition that it self-governs and self-determines its future for its people. And we first talked about the United States. The United States has recognized that formally in executive orders and through legislation, albeit piecemeal, but some of the legislation that recognizes the co-management authority for the tribe and the basin is the Wild and Scenic Rivers, or the Federal Wild and Scenic Rivers Act, that's designating parts of the Deschutes and designating parts of the Metolius River, and they formally recognize the sovereignty of the Confederated Tribes of Warm Springs and its co-management authority of those waters. The state of Oregon also formally recognizes the co-management authority of those waters, principally through the Water Rights Settlement Agreement. There's a provision in the Water Rights Settlement Agreement that formally recognizes the three sovereigns as the co-managers for all waters in the Deschutes Basin, including the waters that aren't actually settled in the agreement. And it actually calls for the formation of an intergovernmental board to co-manage those resources. And that board, for a variety of reasons, has never really been constituted in the way that was envisioned by the parties in the 90s. The water rights that the legally enforceable water rights, Steve, that the tribe has that aren't addressed in the settlement agreement are really the rights to water to sustain the fishery that is protected by the treaty right. So we would take, and this is maybe to take it out of the basin because of issues in the basin. An example is how does that manifest itself? So we'll use a recent example in the Klamath Basin. And in that circumstance, the water users in the Klamath Basin had taken the position that the United States actions related to the Endangered Species Act had taken their water rights in a constitutional sense without just compensation, a Fifth Amendment taking. And the Hoopa tribe, which is a tribe on the lower part of the Klamath River in Northern California, took the position, no, you didn't take those rights because you didn't have those rights to begin with. The right to in-stream flows that are being protected by the Endangered Species Act are also required to be protected for our sovereign purposes, and those predate your rights. And in that circumstance, the Federal Circuit, I think it was in a special court back in Washington, D.C., agreed with the tribe and said, we're not purporting to quantify the amount of in-stream flows that are necessary for the tribe's sovereignty, but we will say for purposes of this case, there are at least as much as are needed to protect these species under the Endangered Species Act. And they denied the claim for compensation. So Warm Springs, I would argue tonight, and this is just me, this isn't Bobby or tribal council, this is just Josh, that because of the nature of the treaty that Warm Springs has with the United States and the express off-reservation rights to take fish and the recognition that in order to have a right to take fish, you have to have fish to take. To have fish to take, you have to have habitat, which includes water. That includes in-stream flows that would be sufficient to maintain a harvestable population of fish. And Steve, you know this because you've been around a long time, even though you left for a little bit. One part we didn't talk about tonight because we thought it'd be too much. As the tribe was settling the water rights settlement agreement, who here, I mean, I'm sure people know, but people know about the Pelton Round Butte hydroelectric project that creates Lake Billy Chinook. So that is a 3-dam complex. The original license was issued in 1950. It's partially located on the Warm Springs Reservation, partially adjacent to. For the first 50-year license, which was issued to Portland General Electric, the tribe and Portland General Electric fought constantly about the appropriate compensation. But the one thing we know is it extirpated anadromous fish runs above the project as of about 1971. And the efforts to maintain an anadromous fishery above the project were effectively abandoned from that point forward. The license was a 50-year license expiring in 2001. Our late partner, Jim Noteboom, who some people know, was representing the tribe at the time. And the tribe and PGE submitted competing license applications. Jim was, to say he was a bulldog but they were hammer and tong with each other. Ultimately, though, they reached a global settlement agreement and they withdrew their competing applications and submitted a joint application. And the tribe and PGE became co-owners in the project and joint licensees. And a key feature to that license is a fish passage plan to reintroduce a harvestable population of anadromous fish above the project. That is trying to restore the connectivity and the cultural integrity of this basin. And that's a big, big part of Bobby's job for the last 25 years.
And you heard me talk about how fish was a main driver for our water and water negotiations. That was the same thing with Pelton and the relicensing. That fish was a main driver to be a partner in those projects to be able to get fish back above the project and have more fish in the system. So again, fish being very, very important to the tribes. And then back to your question, Steve, about co-management, and Josh explained it, but we co-manage with the state of Oregon. As he said, we're recognized with water, with fisheries. We sit down and talk about what are the runs going to look like, what do we do to protect runs and enhance runs. We talk about wildlife and what are we doing with deer populations. Across our ceded lands that you saw, we sit down and have those discussions with the state of Oregon on deer and elk and what our hunting seasons are going to be, what their hunting seasons are going to be. So that's, and making sure we're not creating conservation burdens and taking care of those deer herds and elk herds. So we talk with them on a regular basis constantly. We have staff working with them. So in all those areas and natural resources, we are constantly working with the state and the federal agencies and the Forest Service and the BLM on what's happening on those lands.
All right, yeah, if there are any questions in the audience in the immediate future, I might ask a question from
There's-
online real quick.
2 in the middle and 1 in the back. When Kate, yeah, let's take the online one.
Oh, I have an online question, but let's do a couple more in the room first.
Okay. Got one right there, Yancy,
All right, we're starting the back over here.
and then a couple up.
Roger had
in this, yep.
had his hand up.
Can't see it all.
Hey guys, I'm having trouble using my calculator today, and I'm doing my conversions of acre feet to CFS, and from your chart there, that really wonderful hand-drawn chart, and then trying to relate that to your conversation about 250 CFS of basically consumptive use, and then 200. It's not adding up. So the 1,170,000 acre feet, that's per year, correct? So that's a daily CFS of about 1,600 CFS that you've got protected in stream. So is the 200 plus 250 on top of that? I'm just trying to figure out how the whole water right thing really works out. And then since we all know that the average flow in the Deschutes is 4,000 to 5,000, what's the right, what are the rights around that other water? Sorry for the detailed question.
Yeah. Bob, you want to take the first crack at this?
Go ahead, because he's,
To do some math here.
we told him about the in-stream, but we didn't really, didn't say out-of-stream, which is the consumptive piece, so, yeah, go ahead, Josh.
One of the nice parts is lawyers are terrible at math, so whatever I say won't add up, Yancy. I'm just, that's the...
And I don't have a calculator either.
Yeah, but it's actually a great question, and one that we probably oversimplified it. We took out a slide. So the 250 CFS is for on-reservation uses only and can be taken only from on-reservation sources. So that probably helps answer part of it. And then the in-stream water rights, if you look at the settlement agreement, they were designed to do several things. First of all, to try to maximize the amount of water in stream for the ecological purposes, but they had to be developed in a way that was consistent with and did not conflict with the hydro project and the in-stream flows required for the project. And then they were also developed in, I don't want to say in tandem, but in coordination with the state in-stream water rights. And the notion that the tribe's water rights, the oldest in the basin, but can't be no water right older than January 15, 1991, can be curtailed in favor of the tribe's right. That was the big political compromise. And that date was actually, I think, a day earlier in the original agreement. And the only amendment to the agreement was to change that because there was an error. And it had to do with the ODF and W in-stream water rights, the priority dates associated with those rights. I can't remember quite why the change was made, but that is right. So those are tied, the protected reach for the in-stream water rights are all around the reservation, but the main stem Deschutes is somewhere between 3,500 CFS in certain months up to 4,000 or 4,500 CFS in other months. And they are all but the driest of years, they're met, I believe.
Yes,
All right, I think we have,
Roger.
yep, right over here in the
Can
center.
I see that hand again, so I know where
there's
to take
Roger.
this mic?
I can't hardly see it is bright.
Here you go, sir.
On the subject of dams, were the various tribes along the Columbia consulted on the construction of the dams on the Columbia, the Dalles and so forth, and maybe even along the Snake? But that's one thing. If you guys were consulted, and because of the significant impact on the fishery, obviously, but also, secondly, how is the Pelton Dam resolution on the fish passage? How's that working out?
We were consulted that they were putting dams in on Columbia.
By consulted, you mean told?
Yeah.
I can help with the first question, and you can probably help with
Yes.
the status of the reintroduction, the fish passage plan. Roger, is a great question. The first question, So in the early part of the 20th century, Congress surveyed and mapped power reserves in the western United States. And for the Deschutes, like I think as early as 1910, where the Pelton project is now was identified by Congress as potential hydropower site. And you have to think about, it was being developed in 1950, and another thing we didn't cover is there was sort of this pendulum swinging at the national level about tribes, tribal sovereignty, and what to do with tribes. And that when the Pelton Project license was issued by the Federal Power Commission, now FERC, in 1950, you were really entering a dark period at the national level with respect to tribal sovereignty. It's what is known as the termination era. And there was an effort to terminate the federal recognition of tribes and really force assimilation. And in Oregon, in particular, the Klamath tribe its recognition was terminated. Some tribes in Western Oregon. Warm Springs was not. But in terms of consultation with that project at that time, the national policy would not have been to consult with the tribe. And so that was not a good time. Main Stem Columbia, I think, is similar in terms of the Dalles Dam that flooded Celilo Falls, I think. They closed the gates in 1954?
1954, and then just in several hours, the falls were gone.
So there really was not the notion of so really a big thing now is government to government consultation. That if you can have staff level consultations with tribes, but in the Northwest and with Warm Springs in particular, if you want to talk about big issues, you have to sort of bring a comparable delegation to the tribe. So if you're going to meet with tribal council, and it's the state of Oregon, that generally means the governor. There are some, and then at the national level, if you're meeting with tribal council, that's usually senior agency people, Secretary of the Interior, their principal deputies. The same might be said for National Marine Fishery Service. Some tribes will hold out for the President of the United States, but that's a tall order, as you might imagine.
How about part
you
two?
got to talk about fish.
Yeah,
fish,
fish passage.
Fish passage. So there is a fish passage there. When they first developed it, they had the world's longest fish ladder put in place. It was not successful. They were able to get adults up above the project, but the problem was getting the little guys out. And there's some reasons for that with the Round Butte, with the way the currents come into the reservoir there. When the fish start coming out, the little guys and the smolts, they hit these currents, and some of the currents actually come back upriver again, and they would get lost. So it wasn't very successful. So there was a lot, and probably some people, I think Yancey was involved in some of these early discussions, is how do we get them out? There was a lot of engineering, a lot of folks, a lot of smart people looking at, well, we need to create a current that makes it so they can go get out of here. And so that's how the fish facility, fish tower, came to be. It creates this current and to attract those attraction flows, they call them. And they bring those fish in there, then they're able to catch them, put them in a truck, and then take them around and put them down below the project area down by the Ray-Reg Dam. And so those fish are now able to go out. They've imprinted in the waters up above, and a lot of them are, what we're seeing is the Crooked River. A lot of salmon, steelhead want to go up the Crooked River. There's some that go up the by Choose, and we have, there's quite a few fish that went up the Metolius. So we're starting to see some surprising successes at times. Other times we're like, oh, wish we could have done better. We have spring Chinook salmon going up there. sockeye, and summer steelhead are those the native species going up there. We were really surprised here. I can't remember now. I want to say a few years ago, maybe not that long ago, but we had a pretty good stock of sockeye show up one year, and it's and I think, and I see Yancey nodding his head, really surprised us on how they came in and the size of them. I was really surprised. I went down and looked at them. They were a pretty good sized fish. So we're seeing some successes, and we just want to continue that, and we want to be able to have some good habitat above the project areas also, and help get more restoration work done for fish habitat in the upper basin. So we're working pretty hard at it, and we're constantly looking for funding to do that. So.
All right. Other questions? I think we had one here, and then there's one there that I see. So Jacob, right in front of you. Becky, you.
Right in front of me, huh?
Right in front of you. Raise your hand, Becky. Raise your hand. Okay.
I was under the impression that it was the federal wild and scenic designation that declared the amount that had to show up at the Madras gauge. Was it more your tribal rights and amounts, or was it hydroelectric? What all made that amount be kind of sacrosanct in the discussions?
So the in-stream flows at the Madras gauge, the legally enforceable rights to assure that those waters are there are really driven by state law, principally, with the exception of the Water Rights Settlement Agreement. And Oregon is pretty innovative in that it has recognized a beneficial use to use water in stream for a significant period of time. California, to this day, there's a process for it, but it's cumbersome and it's subject to challenge. But Oregon's, and so it's protected like any other water right, meaning it has a priority date. And so in times of shortage, one of the fundamental principles of the doctrine of prior appropriation is that in times of shortage, the senior water rights are filled completely before the junior water rights get any water. So almost every in-stream water right in the state of Oregon would be considered a junior water right and at risk of being regulated or curtailed in times of shortage. That includes the tribe's water right in the settlement agreement, but would not, in my view, include the tribe's reserve water right protected by the treaty that has not yet been settled. My argument would be the right to in-stream flow there is from time immemorial and would be senior to any other water right.
All right, I think there's someone right there. Yep.
Yes, there was.
And then we probably have some questions online.
Thank you for all of the very interesting information. I had a question regarding something that we have in our table about the rights of nature and personhood for the Deschutes River. I am particularly interested with what it would mean for Indigenous people in Oregon if the rights of nature and personhood of the Deschutes River were recognized. I'm interested in this because in Ecuador, in our Constitution of 2008, the rights of nature were actually incorporated in our Constitution, and it hasn't had, I think, as many broad implications as a lot of people hoped for, but at the same time, this constitutional right of nature has been brought up in different legal lawsuits of indigenous communities for sovereignty and land rights. So I'm very curious of what this would look like just in a context of Oregon and indigenous rights in the U.S.
You want me to take a crack?
Yeah. You've got international laws.
Yeah, exactly.
Yeah.
You're the lawyer at the table.
So that is a fascinating question. And I only have, I will say a caveat, sort of a limited experience in dealing with what is really, I think, a cutting edge issue. and I'm not familiar with Ecuador, but I know the Philippines are considering these notions of legally enforceable rights of nature in and of themselves, right? And so I think, and I am not an academic in this area, but one of the things that in the continental United States has contributed to the discussion broadly is this notion of a trust and who are the beneficiaries of the trust. So there's also in natural resource law another body, a well-developed body of law in the United States known as the public trust doctrine. And the public trust doctrine has been used in an effort to sort of protect the resource for the sake of protecting the resource in California, and for the idea of trying to create beneficiaries of that resource. And water, there's some public trust doctrine cases dealing with Mono Lake, which is a source of water for the Los Angeles basin, with varying degrees of success. And there's a professor at University of Oregon named Mary Wood, who part of her argument in taking a different view of protecting nature for nature's sake, there's a book she's written called Nature's Trust. And her argument has been you should borrow from the tribal trust relationship with the United States because it's the most developed and the most protected as a way to look at protecting the environment beyond traditional ways. I don't know if that really gets at your question, except to say that I think the trust relationship with the United States and how that's manifested itself, I think academics are looking at, can you borrow from that, right? I mean, that's really law. Law is about sort of adapting something that's worked somewhere else to your situation.
So Josh, you talked about the public trust, so you might want to elaborate on the tribal trust doctrine.
Or maybe you should. This is the point in the presentation where we turn on each other. And then Lisa's going to have to separate us. No, I'm happy to do so. I was mildly joking.
Yeah. So, well, let me just, I'll say on that and I'll turn it over to you. So there's two, and I always do this to the Forest Service and the BLM when I talk to them, and I always ask them, what's your number one priority in your job? For who do you have trust? They always say, well, we got public trust doctrine. And I was like, no, wrong. Your number one priority is tribal trust doctrine. Take care of all these things that I just talked about and Josh talked about tonight. So there's two doctrines there. One's the tribal trust doctrine and one's the public trust. And their number one priority the feds have are to the tribes on the tribal trust doctrine. So I remind them regularly of that. And I'll let Josh chime in on.
Yeah, and actually, you just reminded me as you were saying that, you know, we're not talking in a vacuum. There's actually a case pending before the United States Supreme Court right now involving the Navajo tribe and water. And the Navajo tribe has taken the position that the United States trust responsibility extends to advocating on its behalf in water rights adjudications in Arizona. And the Ninth Circuit agreed. And they actually brought an action for breach of trust and were seeking not money, but they were seeking judicial relief, sort of requiring the United States to take certain actions. And this is one of those interesting things where it kind of doesn't depend which party is holding the White House necessarily. The United States is opposing this, and then there's a whole raft of other interested parties saying that's really not within the scope of the trust responsibility of the United States. And because if it is, and they have that obligation, then that could sort of really change the dynamics in terms of settlement negotiations and elevating tribal interests to a higher level. And on Warm Springs Reservation, we talk about these things again in the abstract, but in Warm Springs, and we thought this might come up tonight, people who've been in the basin for the last several years, you read in the paper the potable water issues, the water supply issues, the water system issues, and that's not unique to Warm Springs. The Navajo Reservation, they still have people who drive miles with a 50-gallon drum that they fill periodically and take it back to their home, and that's what they use for water. And so you have these reservations that are, in theory, owed fiduciary obligations by the United States to help promote their self-governance, their sovereignty, and fundamentally their dignity. And so, the United States doesn't, in my experience, really know how, at a governmental level, there's individuals that are great, some that aren't, but at a governmental level, how you establish systems and fund them to discharge that duty. I mean, it's kind of gallows humor maybe to say, nobody would ever hire the United States to be their private trustee, and yet they are the tribe's trustee, and they don't want the job, but tribes say, look, Warm Springs will say, look, and actually the way you see it manifest itself now is under the notion of self-governance. We want you to govern. We don't, this is for you to decide. But tribes will say, oftentimes, you can't abandon your fiduciary obligation to us under the guise of self-governance. You came, we negotiated a treaty, really, but it was an adhesion type of contract where we ceded 10 million acres of land that includes places like the city of Bend, Redmond, and all of this value for virtually nothing. And we didn't want to do it. But part of what we got in exchange was a perpetual fiduciary obligation to assist us. And in our country, that's a difficult thing to reconcile because we don't really deal with sort of this positive obligation welfare issue in a way other countries might. And I am evangelizing now, but I think part of what we struggle with from a constitutional framework perspective is the tribes don't fit neatly in that. So we have the trust issue with the Navajo tribe pending before the U.S. Supreme Court. We also have, it's not water, but an Indian Child Welfare Act case, the Brackeen case, which is fundamentally going to the heart of what it means to be a distinct political community, a tribal community, and how our constitutional framework recognizes it, protects it, respects that dignity. And it's a constantly changing landscape.
It is. Mm-hmm.
So, see what I mean about the fount of smartness that you're saying?
Right?
Super interesting conversation. I do feel like I need to clarify the postcard on the table. It's a really intriguing idea. It didn't come from the DRC, not that it might not be a legitimate idea, but it has a web address that looks like the DRC's web address. So I just wanted to clarify that you should go talk to whoever brought these and have some conversations, but this is not something that we're at this time passing around. This is not our note card.
That's really interesting.
So, just wanted to clarify that. And there's a couple of specific questions diving into the Pelton Round Butte, but I think I want to just, if it's okay, take it in a hopefully not too self-serving direction. But Josh, you mentioned that the in-stream water rights are all junior, and there are tools that we have in the state to protect senior water rights in stream. And I was thinking maybe, Bobby, you could talk a little bit about the good neighbor policy of the tribes and sort of how you were involved with, this concept around an organization that could do that work that eventually became the DRC.
Sure, I can do that. So there was a lot of things happening in the 90s. You just heard about our water right settlement and negotiations. In the 90s, we worked on the Pelton relicensing and became partners with Portland General Electric. The DRC came to be in the 90s. And so, part of how that happened is Warm Springs leadership, a mentor of mine, and Jody Kalika, and it was Deepak. We had Zach Willey from Environmental Defense Fund, and some smart people around Warm Springs sitting down. Jim Noteboom was one of them, and talking about, about water. We have all these things going on, and how do we take care of the water that's important to the tribes. And so we've always had this good neighbor policy, the tribes, because our good neighbor policy is our neighbors are always going to be around forever, and so are we, the tribes. And so we need to get along, and we need to be able to work with each other and come up with solutions and problem solve together. And that goes a long ways compared to going into courtrooms and litigation, and where you have winners and losers. So the DRC came out of that discussion of being good neighbors, and how do we pull everybody in the basin together and sit down and have a conversation about how are we going to take care of the water and conserve water and have more water in the streams. How are we going to do water quality and take care of the quality of the water and making sure it's clean, good water. For Warm Springs, you've heard of our challenges with water and drinking water in Warm Springs for a while now. And I always remind folks, we're lower in the basin. We're downstream from Bend, we're downstream from Redmond, Lapine, Sisters. And so, our water comes from the Deschutes River and serves our community of Warm Springs. So we want to do projects and work with our neighbors to be able to have good, clean water also coming down to the tribes. And so this organization, being Deschutes River Conservancy, was one that, hey, we put something together and have groups working together, all different types of groups, and be able to get some appropriations from Congress to start it up. That would be a great thing. And they were able to do that and put together this wonderful group that's been here since 1996 and still doing some great work, some water quality, and there's some great numbers of water that's been conserved and put back into the streams. And also, it's just been a wonderful group. It's one of the, it does the water banking here in the basin, and recognized as a group in this basin also, with a lot of the folks that are in this room, are recognized as leaders in Oregon for water and how to manage water and take care of water, and being able to work together, which is really a cool thing. And so, we need to compliment everyone here and each other, complimenting each other too about all the good work, and having folks here and understanding why we're all together and working and trying to do good things for water. That, as the elder told us, looking out for the 7 generations, looking out for the unborn. Not only just the tribe's unborn, but everyone's unborn.
And Bobby, I would add, because Kate's being polite, another way that Oregon's been innovative is through its conservation program and transfers, where you can transfer senior water rights, or you can engage in conservation projects where water goes back in stream with the senior priority date. Mm-hmm. I think that's what Kate's getting at. And the essential role that DRC has played is being a place where people can get to know each other, because it takes trust. It's complicated, and you need a lot of technical expertise. And so I've always viewed the DRC as a place that concentrates resources and brings the stakeholders together to get to know one another as people. This is why we know Steve. And build trust to do these projects, because there's a lot of uncertainty. With uncertainty, there's usually fear, and people are averse to that, so they're unwilling to do it. And the DRC is a place where people get together, define the issues, and define projects. And without the DRC, many of the big conservation projects that the districts, the irrigation districts, have undertaken in the last 15 years-ish. Kate, is that right? I can barely see you back there, but yeah, it is. that probably wouldn't have happened without the collaborative stakeholder organization that the DRC is. So you're right, I misspoke to say that all in-stream water rights are junior. You can transfer senior water rights in-stream or engage in projects that will result in senior in-stream protected flows.
And I,
Yeah.
The DRC.
yeah, and I can't
How
forget.
the DRC came to be, so thank you.
Yeah, and can't forget the irrigation districts too, because they were a very important player in the startup of the DRC also. So a lot of talks, that's how we know Steve.
And interestingly, maybe this is another point, if you talk to state leadership, I mean, we all have our issues, but they do view the Deschutes Basin and the place-based planning that the stakeholders in this basin have undertaken as a model for water resource management throughout the state.
It's true. We have a big meeting tomorrow if you want to come and hammer out the basin water management plan.
Yeah, we've got Bobby serving as a tri-chair along with Steve back there.
That's
So.
right. Yeah, and I actually didn't mention in your introduction that Bobby's currently the chair of the DRC as well. So anyway, great conversation. Thank you so much, Bobby and Josh, for your time, and Lisa for facilitating. And I'm sure they're open maybe to stick around for a few minutes if you want to ask them anything else. And thanks again for coming. Have a wonderful night.
And next month, I just want to plug that next month
yeah.
we have another Raise the Deschutes to follow up on this conversation. We'll be talking about this, the reintroduction that happened with the Pelton Round Butte facility. So that conversation will happen February, somebody help me, I think it's February 26th. It's on our website.
And the unanswered online questions, you can probably get your questions answered at that next reintroduction session. So apologies we couldn't get to everything.
Thank you all for coming.